Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. You may notice that I've got a little bit of a scratch right there. My cat reminded me who actually runs the household, and apparently it's not me. But today I want to talk about qualified immunity, and specifically the Fifth Circuit decision granting qualified immunity to police officers that ignited a suicidal, gas-drenched man on fire by tasing him. Now, I got the story and was teed up on a story from reason.com. And this is, well, frankly, it's kind of concerning. Gabriel Eduardo Olivas doused himself with gasoline, and the police officers that were on scene set him on fire. About a little more than a week ago or so, the Fifth Circuit, the Court of Appeals to the Fifth Circuit ruled that Jeremiah Guadarrama and Ebony Jefferson, the Arlington, Texas police officers who fired tasers, that's an electrically charged shocking device, at Olivas, igniting him and burning his house down, are protected by qualified immunity. Now, they were on scene because Olivas' son called 911 and said that his father was suicidal. He had been threatening to kill himself. And according to the Fifth Circuit summary, he also said that he had threatened to burn the house down. Now, the family does not agree with that. That assertion actually contradicts the family's account of that. And we can get into legalities, but on summary judgment motions, the court is supposed to accept all the facts against dismissal as true. So in this case, the court didn't accept those facts as true. Instead, it accepted that the guy had threatened to burn the house down. So the family maintains that he didn't threaten to harm his wife, his son, or anyone else in the home. So the police officers arrived, entered the house. They smelled gasoline. Olivas' wife, Selena Ramirez, directed the police officers to a bedroom where they found Olivas leaning against the wall holding a gas can. Now, one of the officers, Officer Caleb Elliott, told the other officers at that time, if we tase him, he's going to light on fire. And then Elliott hit him with a pepper spray. Now, about the same time Olivas dumped gas on himself, it's not known whether that was because he'd been pepper sprayed and doubled over. They just don't know. The other two officers at that time opted to fire their tasers into the gas-soaked man and light him on fire. There's no question that fire is one of the concerns of a taser. Tasers are not non-lethal. They are less lethal. And we can get into that whole area as well. There was discovery before the hearing in front of Judge Mark Pittman. Guadarrama and Jefferson asked to dismiss the case on qualified immunity, and discovery was started. Now, the court ruled that the severity of the threatened crime, felony arson, was considerable. However, I'm not sure that he threatened felony arson. Is it felony arson if you destroy your own property? And by all intents, he owns a house. It might be an improper fire, but it wouldn't necessarily be arson unless he was making an insurance claim, then it'd be insurance fraud. Regardless, we won't get into that. I don't know what the arson law actually reads in Texas, but there's an argument that you can destroy your own property. Setting that aside, the Fifth Circuit reached a conclusion that the officers used reasonable force when they set the man on fire, burned him to death, and burned down the house. Now, the officers were trained to know that a taser in the presence of flammable substance could start fire, but essentially it doesn't matter. The court held that they had the right to use reasonable force. So let's talk about what this means. And of course, that's going to be appealed by the family. So what is qualified immunity? Okay. Because you're not going to find it in the Constitution. You're not going to find it in federal law or even in states' laws, because qualified immunity is a judicially created doctrine developed by the Supreme Court in the late 60s. It shields state actors from liability for their misconduct, even when they break the law. Okay. The primary federal civil rights statute, section 1983, says that any state actor who violates somebody's constitutional rights shall be liable to the party injured. But under the doctrine of qualified immunity, the courts held that such defendants cannot be sued unless they violated a clearly established law. So it's possible and actually quite common for courts to hold that government agents did violate somebody's rights, but the illegality of their conduct wasn't sufficiently obvious for them to be held liable to the victim of their misconduct. So while you can be held to strict liability for some offenses, and a growing number of them, law enforcement is not. Law enforcement, the illegality of their conduct has to be sufficiently obvious. So what does that mean? What is clearly established law? Because that's the next part of the analysis. And clearly established law is very difficult to define. In practice, it's quite difficult for civil rights plaintiffs to meet. To deny qualified immunity, courts generally require not just a clear legal rule, but a prior case with functionally identical facts. Okay. The Supreme Court has always insisted an exact case on point is not strictly necessary. It's also stated that existing precedent must have placed the statutory or constitutional question beyond debate. If we go to the, I think it's Flick decision coming out of Massachusetts, where a attorney was arrested for recording police officers making an arrest. The argument there, and he won, those officers denied qualified immunity because they knew or should have known that recording somebody in public is not freaking illegal. So he won that. However, do we have a statute that says that clearly defines that it's inappropriate for law enforcement officers to set somebody on fire and burn them to death? Well, no. So the argument that would be clearly established as being inappropriate, sadly, isn't going to hold up. I know this is ridiculous. Please send the hate mail to somebody else. I'm telling you what the law is, not what it should be. So lawyers, man, we're paid to split hairs and debate. Okay. So we can debate what might seemingly be obvious and rely upon minor factual distinctions to conclude that, this is different than that. We're distinguishing this conduct from this conduct because my guy wore a red shirt and a blue shirt was used in this conduct. So it's a different situation. So we want to show, they would want to show that, the law was not clearly established on some point. It could be the time of day, the day of the week. It could be the extent. It could be proving that the taser would set the damn place on fire. Okay. So qualified immunity is truly an unjust shield. Okay. It removes the possibility of justice for victims of state actors. Now, this is where I'm going to piss off a lot of you. And I was in the Army. I was stationed in Aschaffenburg, Germany. And Aschaffenburg has a unique historical point about it, in that Aschaffenburg was the location of the first SS killing of Jews on work details. They just killed a couple of people. And they were those SS soldiers were brought up on charges by the city authorities in Aschaffenburg, Germany. Clearly, this is before World War II, but at that time, the state argued that its law enforcement could not be tried by city authorities. So they were above the ability to be tried and prosecuted by the city. It had to come through the military for those military soldiers, and that wasn't going to happen. You have a similar situation in that because of qualified immunity, people who could be brought to an appropriate level of behavior through the civil process are above reproach. And look, we're talking about extremes here. I mean, your average police officer is not setting somebody on fire. I know in the town where I practice law, our law enforcement is largely excellent. I have spoken to officers that have risked their life to save my client's life. I had a client turn and point a gun at a police officer, and instead of shooting him, which is what I would have done, they physically disarmed him without using a taser and saved the guy's life and got him some mental health treatment. Again, if I was the cop in that situation, I'd have shot the guy. So, you know, this is not the norm for police officers. These are the exceptional circumstances we're talking about. Okay. In normal situations, qualified immunity is protecting a police officer from being sued by somebody that got bruised while he was fighting with the police. And that's appropriate. But it's in these extremes where it's not. So, you know, I want to clarify that because it's something that a lot of people don't understand. So, Section 1983 actually developed and grew out of Reconstruction era, and it was a way to hold the government agents accountable when they were continuing the oppression of African Americans in the post-Civil War South. Not that it performed that well for that back then. And I'm not going to get into the details of and the history of 1983. If you'd like, you can look it up. It's a fascinating subject. So qualified immunity defense is available to all public officials, state and federal, when they're sued by someone claiming that the public official violated their federally protected rights, either constitutional or statutory. Now, for state defendants, the cause of action is Section 1983. There is not an equivalent civil rights statute for federal defendants. However, the Supreme Court has recognized a cause of action against federal officers. That was in Bivens v. 6 Unknown Named Agents. I think it was early 70s. So the qualified immunity doctrine is essentially the same for state and federal defendants. If the court grants qualified immunity to a defendant, the case is largely over. Okay, it's a two-step inquiry. First, has the plaintiff established a violation of his or her federally protected rights? Second, were those rights clearly established at the time of the violation? If the answer to either of those is no, then the defendant receives qualified immunity. The lawsuit can't proceed. Now, the clearly established obviously is a problem. So first, have their rights been violated and have those rights been clearly established? It's a two-part, we call it a two-step because they're going to try and dance around it. So we can talk about the rights and wrongs of qualified immunity. And if you can't tell from some of my comments, I have real reservations about qualified immunity because it allows situations like just what we were talking about. When you have somebody who has been so harmed as this family, that the Fifth Circuit upheld qualified immunity after their father was burned to death and their home was burned down. And it, frankly, there was no need for it. There's no reason for it. It didn't have to happen. And I don't think qualified immunity should apply in a situation like that. However, there are a lot of people clearly that do. So that's what qualified immunity is. It's a protection for government officials and people acting at the behest of or under the authority of the government, police officers. So it has severe problems. There are times when it's necessary and it should be applied in favor of the officer. But I think that that two-step analysis has created it's far harder to challenge qualified immunity than it should be. I guess is the way that should be said. So, and don't get me wrong. I mean, if we didn't have qualified immunity, you know, police officers quite possibly could be sued into poverty with ruinous judgments. Although I think that the lawsuits would not target the police officers individually as much as the departments, and I think that the state or the employer will be paying for their legal protection, their defense, and any judgments that are awarded will probably be paid by the employer as well. But they could be, and that's one of the arguments against ending qualified immunity, is it opens up law enforcement to potentially ruinous personal judgments. And I don't know that that'll be the case. I think that it will change policing, but not that it will, not that it would eliminate policing. You know, a greater concern is that it simply shifts the burden of misconduct from the police officer to the public at large. And there's something to be said about that too. I mean, as a citizen, you have a responsibility to keep tabs on your public officials, and that includes your police department, to make sure that they're acting in an appropriate manner. If it costs you and your government some money, I think you'll probably pay more attention. So that is qualified immunity, and that is the Fifth Circuit's ruling in the Olivas case. And, you know, it's a very unfortunate situation, and I hope that they're able to pierce the qualified immunity in that case. The facts are horrendous. So after pumping you up with all that positive news, I'm going to ask you to hit like, subscribe, and, you know, tune in. We'll be talking to you again here real soon. Thank you.